Kansas Court of Appeals is in session.
Please be seated. Good morning and welcome everyone to the April docket of the Kansas Court of Appeals. My name is Patrick McEnany, member of the court. I live in Overland Park. Our court sits in Topeka regularly. I'm happy to have with me today two other judges from the Court of Appeals, Judge Henry Green, who is from Leavenworth, and Judge Anthony Powell, who is from Wichita. We're all here today to hear cases on our current docket. Court of Appeals judges are headquartered in Topeka, but we travel around the state and hear cases all around. We're a traveling court, so we can bring the courts to the people. We have other panels of our court, I think today, sitting in some of the other schools. We have a panel up at KU Law School, and I think at Washburn, and maybe some other places. We always look forward to coming to Johnson County Community College because of the hospitality of Professor Tebby and the good time she always provides for us, and it's an opportunity to meet with the students and give you all an exposure to what the third branch of government's all about. We have three cases on our docket this morning, and then another docket this afternoon, which starts at 1:30 p.m. right back here. When I call a case, I would appreciate if counsel would announce your appearances. We have read your briefs. We have a pretty good handle on the facts. If you wish to launch right into your arguments, please feel free to do so. And I'll keep track of time for you. The first case is set for 20 minutes aside. The others are 15 minutes each. If you're the appellant and you desire to have some rebuttal time, just let me know at the beginning and I will keep track of that for you. By the way, as a resident of Overland Park here in Johnson County, I'm always pleased to be here and to bring these out-of-towners in to see what Johnson County Community College is all about. I gave them a brief tour this morning. We'll have another tour over the noon hour, impress them with what a wonderful facility this is. And had to break the bad news to Judge Powell that Johnson County Community College is actually bigger than Wichita State. Our first case this morning is Oneida Ruby and those similarly situated versus Atlantic Credit Finance, Inc. Will the parties state their appearances, please?
Pamela Welch for Atlantic Credit Finance, Incorporated.
This is Court A.J. Steckline for the Appellee, Oneida Ruby.
All right, thank you very much. Ms. Welch, do you desire some rebuttal time?
Yes, Your Honor, 5 minutes, please.
Okay. Whenever you're ready.
May it please the court?
Counsel.
Good morning, Your Honors. Pamela Welch for Atlantic Credit and Finance, Inc. Atlantic was assigned a default credit account for Ms. Ruby. They obtained a judgment against Ms. Ruby for $1,232.23. A few months after that, the judgment was set aside. Ms. Ruby filed a class action petition against Atlantic, claiming that it was not licensed and therefore unlawfully collected against her as well as other consumers in Kansas. In the motion to certify the class, she defined the class as all Kansas persons who received a demand for payment for balances of less than $25,000 alleged to be owed on defaulted credit card debt who have either, one, paid money to Atlantic or had a judgment against them by Atlantic. Ms. Ruby did not pay money to Atlantic, and her judgment was set aside.
That was after the suit was filed, though, wasn't it?
That is correct.
This lawsuit, I mean.
That's correct. The underlying lawsuit, the suit on account, that was filed during that time.
Could you explain to the students how Atlantic got this account, the process? I mean, how do they get some of these debts to go after, debtors in Kansas?
They are a purchaser of defaulted credit card accounts. Essentially, this was an HSBC account that Ms. Ruby had, a credit card account. These were accounts that had balances of less than $25,000 and were consumer, and they purchased them from other people. And in fact, it was actually sold to another entity when that was set aside, Your Honor, which was one of your questions, the underlying action. It was not set aside as part of this lawsuit.
Wait, I'm sorry, say that again?
The underlying suit on account, you're correct, the judgment was set aside a few months after that suit on account was filed. It was not done as part of this lawsuit. Coincidence, I know, but it was not done or strategic purposes as part of this lawsuit.
Well, let's see. This lawsuit was filed in April of 2012. Oh, wait, no, excuse me.
That's correct. April 2012.
Yeah, okay. The case was removed to federal court in May of that year, and then you filed an offer of judgment for $10,000
That's
to
correct.
try to make this thing go away.
That's
right?
correct. That's correct.
Then, when she rejected that, and that's when you set aside the judgment in August of 2012, right?
We did not do that. I mean, it was done in that case, and it was not any part of our doing or part of this lawsuit, but it was done
Well, it was-
in August of 2012.
It was Atlantic Credit Finance had the judgment. They're the only one that could set it aside.
They did. It was sold, I know, to another party at some point, a Midland Credit
Oh, I see.
Management, but it was set aside at the request, of attorney, whoever handling that case.
Wait a minute. So you sold somebody the judgment that you already had against this lady for $1,200.
Assigned, I believe, assigned.
Assigned it. Well, okay. Well, it wasn't for value then. It was they just
Right.
so. And then they turned around and dismissed it.
Correct. It was set aside. It was set aside 4 months, I believe, after it was filed. Correct.
You're not suggesting that Atlantic didn't have a hand in this.
I really don't believe it did, Your Honor. I know it's an incredible coincidence, and I know that was the only one question that was asked at the hearing, which is what I want to talk about, is that hearing that was it. There was no findings on the record. And it's our position that the district court erred in granting class certification in this case because for 3 reasons that I want to talk about. 1 is that it failed to make a rigorous analysis. 2, Ms. Ruby is not an adequate class representative. And 3, the case is moot. With respect to the rigorous analysis, you kind of brought that up with the hearing, and that was the only one question that was asked at the hearing, which really had nothing to do with whether the class should be certified or not. There was no other findings made on the record.
We've seen the journal entry, the 2-page or 1.5-page journal entry.
Correct. And
I'm sure Mr. Steckline will have to have some splaining to do about that.
Correct. And that was the next point is then after this hearing where no findings were made, just one question was asked, then the court submits a 2-page, maybe 1.5, I think, to be more accurate, order, submitted its own conclusion, findings of fact and conclusions of law, and it's very terse. There's not much to it. It basically just imports the elements and puts them on the page without any analysis. There's no rigorous analysis. Nothing meaningful for this court to review. And
What's
there's,
the significance of a rigorous analysis? Why should he worry about that?
that's what the court requires. That's what, Rule 23, that's what is required to make a finding, that for the elements of a class certification for Section 223, 6223, there must be a rigorous analysis.
For the benefit of the students, could you tell us what you have to do to meet that class certification? You know, the factors.
Correct. I don't think it was done in this case. And for example, I believe that it just stated some conclusory statements that the plaintiff was an adequate class without applying any facts to that, without giving any analysis as to why she was an adequate class representative or why her claims were typical of those others situated with her. And one of the big problems I have with the court's lack of rigorous analysis was with respect to Ms. Ruby being an adequate class representative.
As far as her adequacy, she's an elderly woman,
Correct,
poor health,
correct,
really doesn't know a lot about this lawsuit or doesn't know anything about the law, really.
correct.
How do you, there's a case called Surowitz versus Hilton Hotels from the United States Supreme Court.
Yes.
Where there was a Polish immigrant who spoke very little English, no formal education, doesn't understand the complaint, doesn't know what the suit's about, doesn't know any of the defendants by name, doesn't really know the nature of what they did, and the court said she can still represent the class.
The difference with Ms. Ruby, what really concerned me more, was her diagnosis of short-term memory loss. And she even had, and when she was asked specifically about this credit card, she had no memory of even having this credit card, had no memory of the confession judgment in the underlying suit, had no memory of of it being set aside. So I'm more concerned with some of the mental impairments and limitations that were present with Ms. Ruby. I think just being of advanced age is not per se a disqualification for being a class representative.
These are all facts that will easily be established through the documents, rather than, it's not a matter where her oral testimony is essential on those points, is it?
I believe it is, because it shows that whether she can be adequately representing the class, whether she can actively participate and help counsel in making decisions and in making decisions for the class, that short-term memory and cognitive limitations, I think, is a very big impediment to her serving as an adequate class representative.
Is there a claim that counsel's inadequate to represent the class?
No, there's not, Your Honor, no. And I know there's case law that suggests that just hiring counsel, competent counsel alone is not enough to satisfy the adequacy of representation. We haven't alleged that at all, that the counsel is not competent. We just believe that Ms. Ruby is not an adequate representative. In addition, though, to just the limitations, there was also, she just really had no understanding of the claims. And I know you kind of brought that up with that case you discussed, but she was also very confused with the purported class. She thought it was all about harassment, and because she'd received a letter and sent a letter back that she was on Social Security income that they shouldn't be allowed to collect against her. She was, still believing that she was entitled to emotional distress damages, or that her damages were that she suffered more physical impairment and anxiety and depression. She doesn't want to go to court. All these things.
The petition doesn't allege any of that, though, does it?
The petition?
Yes.
No. And this was addressed, obviously, in the motion for class certification and our opposition to it. It was addressed at the hearing. Ms. Ruby was not present at the hearing. The court was provided with, some deposition transcripts, but asked no questions about her competency or about her ability to serve as an adequate representative, and didn't address that at all in its order. What I think kind of plays into this adequate representative as well is the mootness argument, that Ms. Ruby was, like you mentioned earlier, was presented with an offer of judgment. She was presented with two offer of judgments. Once the case was remanded back to state court, another offer of judgment was made for $20,001 plus reasonable costs and attorney's fees.
She rejected that.
That's correct.
She had a bill for $1,200,
Yes,
and that was wiped out when the judgment against her was set aside?
right, and
And you're offering to pay her $20,000?
that's correct.
That's to make this thing go away and eliminate her as the class representative and make the class go away, doesn't it?
It's a settlement. I mean, anytime a defendant decides to settle a case or to settle a dispute, they do make that economic decision to do that, and that is what this was.
But when, in a class action, you often have people with small claims that are aggregated together simply because the suit is more complicated than can be justified trying to get a judgment for $1,200, get her money back.
Right.
So you want to get all the people who are similarly situated in one class so that for efficiency, it can be litigated that way. So what you're suggesting is you can make all these class actions go away simply by buying off the lead plaintiff who's got very little stake in it financially. And in fact, you're going to pay her almost 20 times what she had in it.
Well, that was when, she claimed she had individual claims under the Kansas Consumer Protection Act, which was why we did try to remove it, arguing that diversity and that the amount of controversy was satisfied. But once it was remanded and it was determined that these was going to be class claims, the class claims were only for disgorgement of funds and voiding of any judgments, which she'd already received. She never had any actual damages. She never had disgorgement of funds, and she wasn't going to have anything voided because her judgment was already set aside. So she's already been made whole. She's not going to be aggrieved. She has no outcome in this case. It should be moot. And I know you.
Do you have some authority?
I do, Your Honor.
What's your best case for that?
There's a split of authority among the federal courts right now on that issue. And I cited in our brief the Seventh Circuit case of Damasco, which is what I think this court should follow.
Masco?
And that was actually a TCPA class action case. And then there's also some state court cases. There's nothing directly dealing with class action, but there's two state court cases, that's Jenkins and Steele, that talk about mootness. And there's nothing in Jenkins or Steele to suggest that it shouldn't be applicable in a class action setting. And so I know while there's a Lucero case out of the 10th Circuit that differs on this mootness argument, I think this court should be more inclined to follow Damasco, especially in light of Jenkins and Steele. In Steele, the Kansas Supreme Court affirmed a finding that the claim was moot, thereby rendering plaintiff an improper representative. Is that it's clear that a non-certified class cannot succeed to the adversary position formerly occupied by the no longer agreed representative plaintiff whose own claim has become moot. And that was also addressed in Jenkins. And I think what's interesting too is, there's been opportunities, you were talking about, buying off the plaintiff, there's been opportunities for legislature to not make the offer of judgment rule or Federal Rule 68 apply in class action settings, and I think it's 2 occasions and it's been rejected. So, I mean, it's a business decision, and I suppose if they do that and another plaintiff can step up to the plate, nothing prohibits them from doing that.
Is there anything to prohibit another party from seeking to intervene and be designated class representative?
Meaning if Ruby is determined to be moot or her claims are
Or
moot,
even-
she's not
even now,
adequate.
While that's up in the air, because it is up in the air now. That's not, well, the trial court has said that she's adequate, but I mean, it's on appeal now.
Right.
Would there be anything to prevent another party from coming forward and saying, I have a claim, I want to intervene, and I want to be substituted for Ruby as the class representative?
Sorry, that's my timer. I didn't know it did that. First time I used this setting. I don't believe there is. I think they would have to follow the proper intervention rules under the Civil Rules of Procedure and file a motion with the court, and then that would be up to the court's discretion whether to allow a new class rep to intervene. And in fact, I believe researching, I've seen cases where that has been done. I know there's been cases where it's been substituted for various reasons, or class representatives have died, and other representatives have had to step in their place, so.
Your 15 minutes is up. You still have your rebuttal time.
Thank you, Your
Thank you
Honor.
very much. Mr. Steckline.
My name is A.J. Steckline. I represent Oneida Ruby. As a little background, I know the court's aware, Atlantic professes to be one of the country's biggest buyers of consumer distressed debt, credit card debt. And there's quite a few of these companies out there, and it's somewhat of a reunion because we have several of these cases going, including one with Ms. Welch, where we argued to a panel where Judge Green was on, entitled North Star versus Bud back in 2011. Basically an identical case, a little different because in that case, Mr. Budd, our client, was sued by North Star and asserted this as a counterclaim. And in this case, Ms. Ruby had a judgment taken against her by going to court and later had to take an affirmative action to rid that judgment. And it is our understanding that that judgment was only set aside, and it's our argument as a result of a class action and as part of the buy-off attempt that we will discuss here in a minute. As far as the rigorous analysis, this case came out of Wyandotte County much like Bud did. It's a different judge with findings of fact much like Bud did. And we spent a year arguing with Judge Green and Judge Liebman and Judge Marquardt that that was sufficient. In that case,
Mr. Steckline, didn't you file a motion for more findings by the district court? Isn't that seem to suggest that you really had concerns about the district judge's findings here?
well, I didn't have to re-argue the Bud case. I figured it'd be better safe than sorry. So I tried to be, more proactive in that case. In this case than that case. In that case, we had an agreed journal entry that came up. There was no record ordered, and so the North Star was complaining about a rigorous analysis. Well, that journal entry was similar to this journal entry. It was 2 pages. It talked about every 223A factor and requisite B factors, not as long as we would have liked it. But the court in that case, I think, took a very pragmatic approach. Dragon says that you have to conduct a rigorous analysis. Now, that's an analysis of the 223 factors, not of every conceivable argument that's made by Atlantic, as they argue. And if that's not done, this court is not required to assume that the trial court did it. This court may, as Dragon says, remand it back. Not required to, but may, okay? Judge Duncan talks about every element. I wish he would have talked a little more, but he talks about every factor. What I think the Bud case court did, and I would ask this court to do, it took a more pragmatic approach. The opinion said, we don't have a copy of the argument. So we'll basically assume she said nothing and look at this. But I think what the court said there was, even if we look beyond the rigorous analysis, we analyze, as the court did, almost every argument that is made in this case. No typicality, adequacy, everything that was presented today was presented there, still found that it was within the court's discretion to certify that class. And it's a broad, discretion. Granted, more rigorous analysis would have been a better practice. But this court isn't required to send it back. In fact, this court, even though it's an unpublished decision, has Bud to look at and say, this court already spent a year looking over this issue. It was pragmatic at that point. Granted, the judge should have done more, but if we look behind this, we still think we're not going to mandate we're going to use our discretion, the may aspect of Dragon, and we're going to say it was within the discretion of the court. So in this case, even though it's a very similar judgment, I'd ask to take the same pragmatic approach. In North Star, by the time it came back, a year or 2 went by, North Star was out of business. There is an element while these debt collectors are collecting this money that we're alleging is unenforceable to keep these things moving. And as you know, these tend to move at a turtle's pace. So, wish there would have been more. I still think he addressed every element there is, and this court, is not mandated to send it back. It's a may standard.
Court, it's making findings of fact. Is our review of the record is, what, abuse of discretion?
Yes, Your Honor. That's my
So we
understanding.
don't do a de novo review of the facts,
That's correct.
and we, of course, don't have any facts in the record, but we don't have the detailed findings from Judge Duncan, do we?
Pretty much, that is correct. As for the adequacy of the representation, this is an interesting case because unlike Surowitz, my client actually was sued by Atlantic before she sued him. So she was plenty competent to get sued. There has been no diagnosis that she has a short-term memory. In fact, she testified that she spoke with her doctors about this and they were fine. She testified 6 times in her deposition that she understands it's not all about her, but it's for the class. She understands the duties. And like many 85-year-olds, she has had health problems and she has memory issues. But as the court noted, this is not a case that's going to be a long, detailed, fact-intensive trial. In fact, I anticipate, based on how other cases were gone, this is going to be decided on the briefs. They didn't have a license. We're claiming it was unenforceable. You know, her testimony is not
Maybe you could
final.
explain what the underlying claim is.
Okay. Well,
I don't think everyone knows what that is.
the Kansas has the Uniform Consumer Credit Code, much like 7 other states in the country. That requires, if you're going to do collect what's called a supervised loan, which is an open-ended account under $25,000, exceeding 12%, which we believe is perfect for a credit card in default, because we all know they're open. We can tell which ones are under $25,000, and I've never seen one less than 12%. What the debt buying industry was pretty much doing as a whole, with a few exceptions, was ignoring Kansas law and collecting for almost a decade many, many, many dollars without getting licensed with the state of Kansas. There's a case from '08 called WANA versus Independent Financial that says if you're not going to get screened by the state and you're going to collect supervised loans in Kansas, those loans are unenforceable in your hands. It gives you a 3-month window once you start collection to get licensed. If you don't utilize that 3-month window, it's unenforceable to you. We've determined that, in our opinion, that if you're collecting money from consumers that is unenforceable, you should not be able to do that, hence being unenforceable. So we filed the class action against Atlantic, asking that that stop. The Bud court said that the definition was too vague, so they told us to redefine it because it could include consumers that had a debt purchase but didn't even know it because they didn't get contacted. They had to have gotten contacted, so in Bud we amended the class definition to match this, where it's evidenced either by a payment or a judgment, okay? To go to the adequacy argument, we have an 85-year-old client, again, who has testified 6 times in her deposition. She understands that she's representing other people. She testified that she felt harassed. There's been a much to-do about misunderstanding her claims because she testifies that harassment is what she felt. We claim that when you sue people for unenforceable debts, that is a form of harassment. So we really think that the difference in the arguments there is kind of a distinction without real consequence. As for the typicality argument, of course, we think the judgment was removed as part of it enabled them to make this argument. But what I've said in the argument too is that this basically just puts her in the same position as Mr. Budd, which the court had already found to be adequate. In that case, Mr. Budd did it as a counterclaim. He didn't have a judgment. He didn't pay any money yet, but as the opinion in Budd stated, his alternative was either let it go to judgment or defend. And so, pursuant to Surpass versus Lowe, he was aggrieved as a consumer. There are different types of damages. In this case, Ms. Ruby either allowed the judgment to continue, allowed to be hauled into court on a debtor's exam, which is what happened multiple times, to assert her Social Security, and basically she rid herself of that burden by filing a class action. We know that wouldn't have happened otherwise. So she is damaged, and the issue is not moot for several reasons. The first thing is that you can argue all you want about the value of the case. They've said they've exceeded the values with the offers, but this is the same defendant that told me that it was worth, or told the federal court it was worth $70,000 when they wanted to get it removed. So I think there's not been any establishment by their own testimony that they've exceeded value. But second of all, I think the distinction between the 2 cases they filed, or they cited, Steele and Jenkins, is important in that in both of those cases there was no motion for class certification on file. In Steele, I think it was a B2 case asking for injunctive relief, which the entire class had already received before they even received process. So, the entire class was moot at that point. And obviously, no motion to file on that case. Jenkins.
Excuse me, let me just clarify. You said when you originally filed suit in April of 12, you're asking for a declaratory judgment, and then you're asking for damages. And this is, of course, before any class proceedings are taking place.
I believe we
What were
filed
the damages you were seeking at that point?
disgorgement of profits
Profits?
to the class. I mean,
To the
disgorgement
class.
of the collection of the profits from the class. So, and I believe the motion in this case was filed at or near the time of the petition. So
Yes.
it was different than the Jenkins. And what's interesting in Jenkins, and it was attached to the Atlantic's motion, at the very end, they say, that there was no motion on file before it came moot. And in that case, I think it was basically whether the class was going to get services, which they'd already were able to get before the class motion was filed. So it's a different kind of mootness than we've offered you more money than you could possibly ever get. But the funny thing is, at the end of that case, they say, we acknowledge plaintiff's suggestions that SRS should not be allowed to buy its way out of a class action by removing the named representatives from the waiting list, much like offering somebody $20,000. We agree with this sentiment, but the record does not suggest that the plaintiffs were moved off of the waiting list or into a waiver program other than in regular course. So, the case cited by Atlantic itself in the last sentence recognizes that we don't like buy-offs. And in this case, it wasn't a buy-off because whatever happened for other reasons. There's no disputing that the $20,000 offer is made only because she's asserting a class. And I think the fact that she's turned down that money shows that she understands what she's doing here and that she is interested in helping this class action.
The case was removed to federal court based on diversity jurisdiction, and the suit was for a sum in excess of, I forget what, is it now $75,000?
That's correct.
Federal court?
What they did,
But that, of course, is not the damages your client, that would be the damages to the class would exceed $75,000.
that's correct.
Your client's individual damages would have only been, until the judgment was set aside, would have been the $12,000 plus maybe fees and maybe it's imputed. I don't know.
On an individual case, we get the greater of $10,000 in statutory damages at the judge's discretion or actual damages. And as they talk about in Bud had a similar issue about emotional damages. He talked a lot about emotional damages like Ms. Ruby did at the deposition. Neither of those parties were seeking emotional damages. In fact, it's not really all that well established of law under the KCPA if you can get those, like you can under the FDCPA, which was at issue at Bud that's not here. So, whether her individual case could potentially be worth more than that, really isn't, as Judge Murguia said, in removing it, really not at issue because she's not seeking that. She's not seeking the statutory penalties, so. But I think that's all I have unless there's any further questions. Thank you.
For your argument. Ms. Welsh, you have your 5-minute rebuttal. Feel free to take it.
It was a little distracting, I apologize. The first thing I wanted to address that Mr. Stecklein brought up, or actually you said it, Your Honor, was we don't have the detailed findings of Judge Duncan, and that's exactly it. We don't have them in the order. We don't have them in the transcript. That's the problem, and that's why we're asking that this court, one, either determine that this case is moot, or in the alternative, reverse the decision that Judge Duncan made, that the district court made in certifying the class. I know he talked to.
How do you distinguish this from that unpublished opinion in North Star Capital versus Bud?
Obviously there are similarities. It was an FDCPA case, but there's actually a lot of dissimilarities. The Bud case was a suit on account that then he filed a counterclaim. So it was never a separate action. He filed a counterclaim for violations of the FDCPA, and then eventually.
That's an important distinction because.
It is. There's several distinctions.
Why?
Well, that was one, and that affected different aspects of the case, from removal and different aspects, offers of judgments and things that were made, but not really in the class sense. which is what you're getting at. But from the class sense, we really never contested that he was an adequate class representative. There was an argument made with respect to him making emotional distress damages, because in his deposition, he thought that he testified about emotional distress damages, took a break, and then they explained that they weren't seeking emotional distress damages, and that was really all we had to attack him as far as being an adequate class representative. We didn't have, the situation we have here with the physical or mental limitations that Ms.
Well,
Ruby
what about,
has.
it seems to me, I'm getting the sense that we got similar generalized findings in North Star.
I think that,
And the North Star court said, no harm, no foul.
the biggest distinction and probably the most important, and Judge Green may remember this, is there was no transcript provided. The court really didn't look at the rigorous analysis that this court is getting to, because they did not have the transcript of the hearing. They were only provided with a journal entry. And in that case, it was an agreed journal entry. In that case, both sides, how we typically do in Kansas, they'll submit an agreed journal entry, and then it was approved by the court. In this case, we submitted separate findings of fact and conclusions of law, very detailed. Both sides put in all kinds of detail and case law, and the judge didn't use that and bare bones and made his own without using any of the information that was provided. So I think those are some really big distinctions as to what the court is being provided with and how the Court of Appeals looked at that issue in that case compared to how you can look at it in this case.
So you're saying in the other case, the North Star, the court just presumed that there must have been this rigorous analysis because there's no record to the contrary?
I think they had a hard time saying there wasn't without having the transcript. Had they had the transcript, there may have been a different outcome. May have been a very different outcome. So I think that's probably the biggest distinction between the two cases. One other point that I just wanted to address was on that mootness argument. Even if the court is inclined to feel that it doesn't moot the entire case, it should affect Ms. Ruby as far as being an adequate class, because it definitely at least creates a conflict of interest. Having the offer of judgment made to her, she had an opportunity to be made whole. She now has no real interest or financial stake in this case at all. I think that creates a conflict. We cited some cases, I know in our brief, the Reed case, with respect to that. It was a 10th Circuit case, and in that case, the plaintiffs challenged Social Security Administration. There was a group of plaintiffs, and the court said that there was no guarantee in the absence of intervention, previous certification, or a plaintiff with a live claim that the Rule 23 requirements of adequate representation and economy will be satisfied. So maybe they didn't accept the mootness argument, but they found it in the context of it created a conflict with this representative.
What are the interests that conflict?
Her outcome, the stake she has in this case. She's already,
How does the other members of the class have an interest in the case succeeding?
correct.
She has an interest now in the case not succeeding?
Well, she doesn't really have any. I mean, really doesn't matter because.
Interest is just a lack of interest, isn't it?
I would agree with that, and I think that a lack of interest would be a conflict in representing the class adequately and making sure that she prosecutes this case on behalf of those parties. She already had her judgment set aside. That's one of the things that they're trying to do for the rest of the class members. And she never paid any money to Atlantic like some of the other potential class members had. So
Having turned down $20,000, it doesn't sound like she's showing no interest in this case, does it? I mean, what you're saying is she can't represent the class because she doesn't have any irons in the fire.
She's not an aggrieved person.
In pursuing this.
She's not an aggrieved person, and that's what
She
the
walked
case.
away for $20,000. Sounds to me like she has, she's exhibited some interest in pursuing this, doesn't she?
Or is she just doing what's told her by counsel? I don't know. I mean, she's not taking an active, I feel like that puts her in a situation where she doesn't have to take an active role in the litigation, which is what the cases that discuss that when a party's not aggrieved, the concerns they have, and how counsel then takes the lead of the case, and there's no party to represent the interest of the class.
The Seventh Circuit case that you mentioned, which supports the idea that the person can't be an adequate class representative if they've had an offer of judgment made to them, is that what that case?
The Damasco case? Yes.
What's the reasoning? I guess I'm thinking about the policy of this. If defendants in class actions were kind of allowed to pick off the named plaintiffs, you could, in essence, defend a suit without really defending the merits by simply picking off individual plaintiffs. What was the Seventh Circuit's response to that concern?
I mean, that's an expensive proposition. I mean, at some point, you can't continue to keep paying off plaintiffs. I think the whole aspect, too, behind...
Cheaper, though, in this case, for example, let's say you lose on the merits, you're going to end up paying more than you would, you're going to pay that money anyway. So you could conceivably save money, particularly if you think your defense is weak, you can defend it by picking off individual plaintiffs and avoid having to pay off the entire class.
Right. But at the same time, Rule 68 doesn't prohibit that in class action settings. I think that's probably the best answer to that they've had opportunities to do that and haven't. I know one response to that was the other circuit case, and that's when they said you file the motion along with the petition at the same time to prohibit that. That's one idea to kind of get around, I suppose, this buying off or picking off of class plaintiffs.
Is that in your brief, that Seventh Circuit case?
It is. Both of those cases, Damasco and Lucerno, are both cited in the brief. Thank you, Your Honor.
Further, counsel? Thank you very much. Thank you for your argument. We appreciate both of your arguments. We'll take that matter under advisement. And we'll move on to our second case, which is case number 109383. Oh, sure. State of Kansas versus Francisco Martinez Perez. The parties state their appearances, please.
Samuel Schreier, the Appellate Defender Office, appearing on behalf of Mr. Martinez Perez.
Thank you. All right, very well, thank you. Mr. Shearer, do you desire some rebuttal time?
Your Honor, may I reserve 3 minutes?
Yes, you may.
Unless this court would desire otherwise, I will intend to argue these issues in the order in which they were briefed. At this time, I do intend to submit Issue 5, the Fourth Amendment suppression issue, on the briefs. If this court has questions regarding that issue, please do redirect my argument. Issues 1 through 4 involve the sufficiency of the state's evidence. When reviewing such issue, this court reviews the trial evidence in the light most favorable to the state and determines whether a jury operating under the correct understanding of the law could return a verdict of guilty. Moving to the first issue, that involves Mr. Martinez Perez's first identity theft conviction. I believe what this case presents is a guilty verdict that relies solely upon the mere possession of a fake driver's license. What happened in this case was there was a traffic stop. Mr. Martinez Perez claimed not to possess a valid driver's license. At a later point, he went through his wallet to try and find an insurance card. Police officer identified what appeared to be a driver's license and asked Mr. Martinez for it. Mr. Martinez obliged. So given those circumstances, I believe—
More than asking him for it, did he ask him if it was his?
He asked him if it was his, and the response was affirmative, but I think given what the video evidence shows and the other statements made by Mr. Martinez-Perez, what he appears to be stating is that the identification card is his. I do not believe that he is asserting that this is in fact a validly issued Kansas driver's license. Mr. Martinez-Perez informs the officer that he got this license from his sister. So I think it would sort of defy belief to think that Mr. Martinez-Perez is trying to assert to this officer that this driver's license is in fact validly issued by the state of Kansas. For that reason, I believe that the Johnson case controls and that the mere possession of another's personal information is insufficient to demonstrate an intent to defraud. Moving to the second identity theft conviction, particularly issue 2, issue 2 in the brief. In this case, the state alleged that Mr. Martinez-Perez stole the identity of a particular person, in this case AS. I am using her initials. I believe having alleged that in its complaint, the state was obligated to prove that at trial. This is a case where there were multiple identity theft complaints. The identity of the victims was necessary to put Mr. Martinez-Perez on notice as to what he was defending himself against. So I believe it was a necessary aspect of the state's complaint. For that reason, their failure to prove that aspect of their complaint at trial creates a sufficiency of the evidence problem.
Can we go back to that driver, your first claim, the driver's license that he gave to the police officer?
Yes, Your Honor.
At the scene. As I understand, identity theft is passing or using any personal identifying information or document containing the same, belonging to or issued to another person with intent to defraud in order to receive any benefit.
Yes, Your Honor.
And that you've cited that State v. Johnson case, which was decided in 2003, where the defendant used his brother's ID to avoid arrest on some outstanding warrants. And the statute at that time required that you had to use a false ID for economic benefit, and I think the court said there was no economic benefit here. Is that true?
Your Honor, it is true that at that point in time, the Kansas identity theft statute required economic benefit as opposed to mere benefit.
And the statute was changed in 2005 to say any benefit, and which I referred to. And that's the statute that applies here, doesn't it?
Yes, Your Honor. But I believe in Johnson, the court reversed on sufficiency grounds, not because of the lack of an economic benefit, but because there was no demonstration of an intent to defraud. And that would be the argument that I would be advancing today, that mere possession of another's identification information does not constitute evidence of an intent to defraud. I mean, one could imagine if I was carrying my brother's driver's license, that would hardly demonstrate that I was intending to defraud somebody with it. And I think that's essentially what we have here.
Did the police officer testify in this case?
He did, Your Honor. In fact, he was the primary witness.
Did he testify that he saw the driver's license and asked the defendant if that was his license, and the defendant said yes?
Yes, Your Honor. That was his testimony at trial.
So don't we, and the state prevailed in the case.
Yes, sir.
So don't we, on appeal, review the evidence in the light most favorable to the prevailing party, which would be the state?
Yes, Your Honor. I believe my response to that would be, first of all, that we also have a video of the traffic stop where you can actually view what the police officer said. And I believe his question was, is that yours, or is that you? And also, I believe that
And he said yes.
Yeah, according to, I don't believe his response on the video is audible, but according to the police officer's testimony, yes.
And so we presume that that's what the jury found because the jury convicted him.
Yes, Your Honor, but I think there is a critical difference here between Mr. Martinez-Perez representing that as his fake driver's license as belonging to himself, and asserting that this is a validly issued Kansas driver's license, which he explicitly, well, very strongly indicated that that was not the case. He said that he got this from his sister. I mean, your sister does not produce Kansas driver's license. You have to get that at the DMV. I believe he stated that this was not from the DMV.
Did he immediately say that, or is that after the officer looked at it and saw that it looked kind of weird? Pictures were off and seal was off or something like that?
The statement that it came from his sister came after the officer ran that through the computer system. But I believe the testimony at trial, the officer asked, "Is this your driver's license?" He replies in the affirmative. I believe that that merely demonstrates that obviously it's in his wallet. It is in his possession. He was not denying that he possessed that document that the police officer was looking at.
You're not suggesting that in order to convict for using a false identity, when the cop asks you for your license, you can't just hand it to him and say, "Here it is." You have to say, "Officer, this is a validly issued Kansas operator's license." You don't have to say that, do you?
Yes, Your Honor, I would agree with you entirely on that point, and that's why I think it's important to note that Mr. Martinez-Perez was actually attempting to conceal his driver's license from law enforcement. He told law enforcement he did not have a valid driver's license. It's only after law enforcement discovered the license in the course of a DUI investigation that, well, essentially this issue came up. Moving to the second issue, I've discussed issue 2. As far as issue 3, I spent a significant portion of the brief essentially arguing that this court should come to a different conclusion than the Meza panel and go back to this court's analysis that was used in Vargas. That remains my position. However, at oral argument today, I would like to emphasize the second aspect of that argument relating to intent. Now, under current Kansas law, and this was not the case when the Meza case was decided, one acts with intent when, I want to get the exact language, with intent with respect to the nature of a person's conduct, or a person acts intentionally or with intent with respect to the nature of such person's conduct or to a result of such person's conduct when it is such person's conscious objective or desire to engage in the conduct or cause the result. And I think that's very significant in this case, because I don't believe that the state demonstrated that it was Mr. Martinez-Perez's conscious objective or desire to defraud anybody. I believe if one looks at the evidence, Mr. Martinez-Perez gave a false social security number for the purposes of obtaining employment. And so the property rights that the Meza panel discussed would have been, in all likelihood, an unintentional consequence of making that misrepresentation.
An unintended consequence?
Unintentional consequence within the meaning of statute.
He didn't intend for the employer to rely on the fact that he had a social security card to get the job? Is that what you're saying?
Your Honor, I would make a distinction between the job and the property interests that the Meza panel discussed. I don't believe I can make the argument that it wasn't his conscious intent or it wasn't his conscious desire or his conscious objective to gain employment. And so with that respect, I would have to argue that employment is not a property interest, particularly at-will employment, is not a property interest within the meaning of Kansas's identity theft statute.
But it's a benefit.
It is.
Most people think having a job is more beneficial than not having a job.
Correct, Your Honor. I would have to make a distinction between the language in the statute referring to an economic benefit and an intent to defraud. The statute requires both. It requires an intention to defraud and an intention to defraud for economic benefit, or benefit, just benefit now. And that intent to defraud is a different element of the offense than to merely obtain benefit. Very quickly, just arguing the fourth issue, I believe combining the holdings of Seabury and Hudson to sustain a felony obstruction offense, that this court needs to have evidence that an officer was investigating or performing duties related to a felony offense, and also there must be some related underlying felony offense. Here we have an officer who subjectively believed he was investigating a felony identity theft offense, but for the reasons argued in issue 1, I would submit that there was no actual underlying felony, and therefore the insufficient evidence supports a felony obstruction conviction. I would ask this court.
What was the crime you thought he was investigating?
He believed he was investigating a felony identity theft offense. That was the conduct that resulted in his first conviction.
I thought he was investigating a misdemeanor DUI.
He was, Your Honor, but when he found the fake driver's license, at that point he subjectively believed that he was investigating a felony identity theft offense based on his understanding of the law, which I think is understandable given that in this case, Mr. Martinez-Perez was actually convicted by a district court judge of that offense. Nonetheless, I believe as a matter of law that that was not felony identity theft to passively possess a driver's license, and there being no underlying felony, there can be no felony obstruction conviction. It would have to be a misdemeanor. If this court has no further questions, I would waive the remainder of my argument for rebuttal.
Let me get that straight. You're saying the cop was investigating felony identity theft, but since there was no theft, no actionable identity theft,
Yes, Your Honor.
this claim has to fall.
Yes, Your Honor. But it could be reduced to a misdemeanor in the district court on remand.
And you're not claiming that the underlying crime was the DUI for which he was stopped?
Well, that was also another underlying crime, but not the basis for his conviction, not the basis for his felony conviction.
Okay, all right, thank you.
May it please the court, the state of Kansas appears by Stephen Obermeyer. I'll address the issues in the same order. As far as issue 1, the defendant is stopped and the officer asked for his driver's license. Usually you don't want to provide somebody else's driver's license when you're stopped for drunk driving. In this case, Francisco Martinez-Perez had a prior DUI conviction, so this would have been a second-time offense. So it would have behooved him to say, my name is Francisco Sotelo, and here is the identification card that comports with that. I think in a couple of these issues, maybe the issue is driven by what the standard of review is, and just for the benefit of our audience, because I know the court knows what the standard of review is, it's whether a rational fact finder could fairly conclude that this crime occurred, and the fact finder is not obligated to accept the defendant's version of the offense. So if we get a Bill Clinton type of response that, well, I said it was my license because I was possessing it, but it really wasn't me on the license, a fact finder doesn't have to believe that that was the purpose for possessing the driver's license. Well, so that's what I think. The officer said, "Is that your license?" The defendant said, yes, it was his license. So I think that would be more than just mere possession of a fake driver's license. He is using that driver's license with intent to defraud the officer in order to receive a benefit. The statute, the identity theft statute also prohibits just possessing the driver's license with intent to defraud in order to receive any benefit. And the court and counsel discussed State versus Johnson a little bit concerning that, so I'd just like to discuss that. Judge McEnany and Green, you were both on that Johnson panel, and I think it might have even been argued out here. But at any rate, Johnson is arrested at a Home Depot for forgery-related offenses. After he's arrested, in his wallet, he has his brother's driver's license. So he wasn't presenting it to anybody to get out of a DUI. He just had his brother's driver's license, and he said, I intended to use my brother's identification to avoid arrest on outstanding warrants. Now, it's important in these identity theft cases to see whether the facts occurred before 2005 or after 2005, because the statute changed from any economic benefit, which is what happened to Johnson and Meza and City of Liberal versus Vargas, and what we have in this case. And in Johnson, the court did not think that his possessing the license, his brother's license, was with intent to defraud for any economic benefit. So it's a little bit different from this case, even if we go with the theory that mere possession of a fake driver's license would be a crime. As far as issue 2, the complaint alleged that a identity theft occurred, and it listed the name of the Social Security card holder in the complaint. At trial, the name of the Social Security card holder was not proved. And so the issue is whether the state must prove everything that it alleges in the complaint, or whether the state must allege what is required to be proved in the statute. And in this case, the identity theft statute required proving that it was the Social Security number that belonged to another person, and that was all. We don't have to prove the name of that person or have them come in and say, no, I didn't give Francisco Martinez Perez permission to use my Social Security number. It's not required. It's surplusage in the complaint. It would be like a complaint alleging aggravated assault with a 44 caliber Smith & Wesson where that wasn't proved. Just proved that it was handgun or revolver, as opposed to what model and make it was. So,
did the jury instructions mention the victim's name?
This was actually a bench trial, so I think
okay.
I think the judge just went based upon.
That's right. This was yeah, right.
I think the judge just proceeded based on the either used PIC or what was in the complaint. But again, it's not.
Well, the PIC instruction doesn't have that's our pattern
Correct.
instruction that we use for instructing juries
Yes.
in all jury cases, civil and criminal. Do those instructions say you're supposed to insert the name of the victim? The
pattern criminal instructions for identity theft do not require inserting the name of the victim as an element. So the PIC committee does not think that's an element. The statute says another person's Social Security card, which is all that has to be proved, as opposed to who it belonged to and whether or not they gave permission or not. And there was an exhibit admitted in that regard from the Social Security Administration that, and it was read into the record, that basically said the Social Security number does not belong to Francisco Martinez Perez, and the Social Security Administration has determined that it is a valid number assigned to an individual. So I think that element was met. And the defendant was on notice as to what he was defending himself against, in that the name of the victim came up by defense counsel in closing argument. So there's not any surprise, and it really doesn't matter whose Social Security number it was, as long as it wasn't the defendant's, and that's what had to be proved. Moving on to issue number 3, the providing false.
That's giving giving his employer a false Social Security number?
Yes. The defendant obtained employment at I think it was a bar in Shawnee, based upon the false identification documents, and the employer came out and said these were the documents provided to me. In fact, the employer thought the defendant's name was Francisco Sotelo, and this person had been having Social Security received benefits being employed as that, received wages under that name, and so I think there was a benefit that this person received by having a job under that name. I would liken this case to State versus Oswald, which dealt with a person who had bad credit and could not get a cell phone with bad credit, and so they used their friend's credit information and Social Security number to obtain cell phone service in that name. And this was after 2005, when the language of the statute changed from intent to defraud for any economic benefit to for any benefit. And the Court of Appeals in Oswald said that Oswald got a benefit by getting cell phone service that she could not have otherwise obtained. And in Mesa, which was also discussed earlier, Mesa was able to use somebody else's Social Security number information to obtain a job, which they could not otherwise obtain. So I would ask this court to follow Mesa and not the Vargas case. One of the problems with the Vargas case is not only was it before 2005, before the amendment, but also the false Social Security number did not belong to any person. So that was a factor that the court considered in Vargas in affirming the dismissal of the identity theft related charge. With regard to issue number 4, the obstruction charge, as it's argued, it kind of...
Clarification, we're talking about obstructing an officer in performing his duties by giving him false information that causes him leads him astray for a while.
Correct. Officer Hill in this case was told that the defendant's name was Francisco Sotelo. He was given the driver's license, which is disputed as to how he got it, but he goes through the field sobriety tests and the arrest and the booking process of Francisco Sotelo, fills out the arrest report,
Okay,
takes him to jail.
When did this offense occur? What event brought about this offense?
The
Is it
obstruction.
Yeah, when he handed him when the cop says, "Is that your driver's license?" He says, "Yeah, here it is." Is that when it occurs? Is that when he first tells him, "I'm somebody else"?
I think that's when it started, because if I said that's when it occurs, then can we have charged a separate count when he provides the false license and every other time? And I think it'd be one, that's closely connected in time, and it would be one offense that
Well,
would
he
be
only gives the
charged.
license to the officer once, right?
And says his name.
Doesn't the crime occur then?
I guess it does.
And what, at that time, to determine whether it's a felony obstruction or misdemeanor obstruction, it depends on what the officer's investigating at the time, doesn't it? If you're investigating a felony, then leading the cop astray can be a felony.
Correct. And the case,
What was he investigating here?
Well, I think Officer Hill testified when he received the license, he did not think that was a legitimate license based on the spacing and there wasn't the imprint from the state. So I think he thought there was an identity theft early on and did not realize it until he had taken the defendant to jail. The jail says, hey, these fingerprints match up with Francisco Martinez Perez and not this Sotelo person.
That's when the fraud is uncovered, but I'm asking about when the fraud is perpetrated. Doesn't that happen when he gives him the license?
I think it, I just want to look at the elements here. Interference with law enforcement is.
Opposing counsel's kind of given up the ship on that point, but I'm not quite ready to quite yet. So.
You want to raise an issue, consider an issue not raised for the first time on
raised.
appeal.
You know it's raised.
Well, he's raising the issue of mere possession is not, doesn't get you there.
That's not the issue. It's the argument.
Okay.
And that does raise a bit of a quandary as what we do with that because of that admission. But.
Right, and I briefed it addressing the issue as raised, but if you want to talk about State versus Hudson and State versus Seabury, Hudson says if the defendant stopped for running a stop sign and runs, and the officer doesn't know he ran because he has a felony warrant,
right, then
it cannot be a felony obstruction. That it's not a status offense. You have to go based upon what the officer knew at the time.
So what was the offense he was investigating? Was it a misdemeanor or a felony?
Well, when Officer Hill gets the driver's license, the false driver's license in the name of Francisco Sotelo, what if he fled at that point? Would that just be a misdemeanor DUI? I think it would be a felony because the statute says.
Well, we're not talking about at this point, what the defendant does. The defendant's already done something. He's given him the license.
Okay.
Now, the question is did he give it to him in the connection with the officer investigating a felony? And if he does, it's a felony. If it's a misdemeanor, it's a misdemeanor. So what offense is the officer investigating at that point?
I think he's investigating a felony and a misdemeanor. And I think it's more of a continuing offense, kind of like in Mesa, which I think you were on. The court said that's a continuing offense, this identity theft business. And so the defendant never corrects himself and says, my name isn't Francisco Sotelo. He goes on for however long it takes to do the field sobriety and be booked under that name. The obstruction statute says in the case of a felony, interference with a law enforcement officer is a level 9 felony. Now, Officer Hill believed he was dealing with Francisco Sotelo based on the verbal ID, the name on the ID, arrested and booked him as Sotelo, and he had to go back and change his arrest report based on that. So I think it would continue to the point where he's filling out the arrest report, because you're probably back at the station doing booking questions, and he's maintaining I'm still Francisco Sotelo in order to do that. Now, so this is a little bit different from Hudson, and it's a little bit different from Seabury, which was a case where a dad comes home and the police are doing a search warrant because they think the son is trafficking drugs, which is a felony, and then the dad blows up and gets arrested for obstruction for the felony. Well, they never find any felony drugs. They find misdemeanor marijuana. So the dad is charged with misdemeanor possession of marijuana and felony obstruction. And the court says, well, no felony was committed, nor were felony charges filed based on the investigation. And I think that language from Seabury is very important because in this case, felony charges were investigated and were filed based upon that.
What were the felony charges filed?
In Seabury, there weren't any.
No, in this case.
In this case, the counts, count 1, identity theft, count 2, or count 3, or I'm sorry, count 1 identity theft with the false driver's license.
Okay. But that's not the crime that he was investigating when he asked for the license, was it?
He was stopped for suspicion of DUI. And I don't know what Hudson would say if the defendant had 2 priors and it's a felony DUI. I guess it's still misdemeanor obstruction. I don't know. But during the course of the investigation, the defendant says, "I'm Francisco Sotelo." At some point, the officer knows there's a felony identity theft, and the defendant is claiming he is Francisco Sotelo. So I think that would get you to the why he was charged with the felony obstruction of official duty during that course of time. I just want to state one thing on issue 5. I know we briefed it, but one of the things the defendant did before he got stopped was he crossed a solid double yellow line, both wheels. And I think that's different from State versus Marks, where you just cross the fog line on the right side, no harm, no foul to anybody else. If you're crossing a solid double yellow line, I think the officer can make a stop for DUI in that situation. So for those reasons, I would ask this court to affirm the defendant's convictions. Thank you.
Thank you very much. Rebuttal?
Your Honor, just briefly, with respect to the amendment to the DUI statute, the identity theft statute, I just want to clarify that the sufficiency argument that we're making is with the intent to defraud, and that the intent to defraud, that statutory language, has never been changed by the legislature. The only thing that has been changed is their definition of with intent, which is quite different now. And so for that reason, I believe that the rights in this case that were altered or intended to be altered need to relate to property. And then as far as issue 4, I do recognize that was possibly not raised as ably as it could have been, but it certainly is our request for this court to consider all applicable law when deciding that issue. If this court has no further questions.
Thank you very much for your argument. Take that under advisement. Move on to our last case for this morning, which is case number 109397, State of Kansas versus Aaron Christina Darrow. Okay. Ms. Davis, you like to, yes.
Yes, I would like to reserve 4 minutes for rebuttal, please.
Got it.
You know, this is actually the easiest and simplest case on the docket. Very straightforward.
Let's see if we can mess it up somehow.
Yes. So we can take our time with this one. It's in a very unusual posture because usually this court's reviewing jury trial verdicts and even a bench trial where a judge is the fact finder, there's evidence, and a judge has to determine credibility and make findings of fact. There's no fact finder here. This case was presented to the district court on stipulated facts, so the facts are not contested. The only question is, as a matter of law, do those facts constitute a crime? And the reason, just to give this court some background, the reason we got here is because the state agreed that Ms. Darrow did not drive to the location where her vehicle was found. She was found with the car running, with the car up against a fence, in the driver's seat, passed out, asleep. And my understanding, the reason behind that stipulation is there are witnesses that came forward that said, we drove that vehicle. She was a passenger, there was an argument, so somebody left her there in the car and walked away. And that's, the state apparently believed those witnesses, and that's why we got the stipulation that we did. And so it really, that's a game changer because, you know, I think there's this perception out there, even among attorneys, that if you're found behind the wheel of a car and the car's running, you know, you're sitting in a car and the engine's running, you're going to be found guilty of a DUI. What's behind that presumption, and most of the cases that are in the state's brief, is there's an inference you drove there. The state in its brief says, they give you all these cases from jury trials and bench trials where the defendant's passed out and the car's running, but if you look at those cases, Hazen, Dill, Sprague, they're in the middle of a highway. They're in the traffic lane, they're in a street. They quote ire, where the car's halfway in the street and halfway in the driveway. Nobody saw the car get there. Nobody saw movement, nobody saw the person drive, but there's an inference. The jury listens to what the defendant has to say. You look at Kendall. Kendall claims somebody else drove there. He got into the car. He put his foot on the brake, the car's running, and he fell asleep.
Under the statute, do you have to show that you operated the vehicle in order to get a conviction for DUI?
Operate or attempt to operate.
Attempt to operate.
Right, and that's really the second question in this case. I think that's what the lawyers did then, is they said, Judge, based on this, do we have a crime? And the question then is, what do you need to do to operate a car? Is any act involving a car sufficient, or do you actually have to be driving or attempting to drive? And that's really the legal standard here. And so basically, when she's passed out in the car, the officer's knocking on the window. Apparently, it took some effort to wake her up. In waking up her, she fumbles. Apparently, she reaches down and fumbles with the gear shift. That's the stipulation. And what the attorney said is, Judge, is that enough? Is fumbling with the gear shift enough to constitute operating or attempting to operate? Now, at first blush, you might think that's enough, depending on how you construe operating. But it's not just any act involving a car. It has to be an act that Kansas Supreme Court has said operating means driving. So you have to be driving or attempting to drive the car. So any sort of action involving a vehicle isn't sufficient. If I'm intoxicated and I open a car door, or even if I start the car, that's not enough. I have to be attempting to drive. So, you know, it's kind of, it's not usual for me. I'm actually before you today telling you and trying to convince you that Ms. Darrow's not guilty. And I don't usually make that argument as an appellate lawyer. But that's basically what you have to determine today. You are like a jury or a district court. And I almost feel like I get to go twice here, but it's almost Mr. Obermeyer who should go twice, because he's got the burden of proof. He has to prove her guilty beyond a reasonable doubt. And my argument is that there's reasonable doubt here.
You want to give me your rebuttal time?
So I'm here to say basically that this isn't enough. This stipulation that says that upon being awakened by the officer and she's intoxicated, that her fumbling with the gear shift is not enough. That's reasonable doubt. Mr. Obermeyer is going to try to say, well, there's an inference there that in fumbling with the gear shift, she was thinking about trying to drive that car, or she was attempting to try to drive that car. Possible. That's possible. But we don't know, because there's another inference that you can draw, and that is because she's startled and she's in this state that she didn't know what she was doing. She's just fumbling as a response. And right after she fumbled, she did not put the car into gear. Her foot was in, there's no evidence that her foot was on the brake. There's no evidence that the car was put into reverse. She opens the car door and she responds to the officer. So it's our contention basically that the evidence that you have, the stipulation that you have, is just not enough to convict someone of attempting to drive a vehicle. There's a couple of points I want to make about the state's brief. One is just, and I already talked about that, is that all those cases that they're citing in there are basically, there's a lot more to those cases. Like, for example, when Mr. Obermeyer in his brief says, well, if you're behind the wheel of a car and the car's running, that's enough. But if you look at those cases, there's other facts there where they're in the middle of a street and a jury or somebody has determined the credibility and decided that they were actually driving and weighing credibility. You guys, of course, don't do that. There's some cases he talks about, like attempting to drive, where the car died. There's evidence he drove to the scene. He's trying to start the car, and that's enough for an attempt. But again, you've got somebody determining credibility and deciding that him trying to start the car, that he was intending to attempt to drive. The state says that this is not an intentional crime, and the state's right. You don't have to, if you had to intentionally drive intoxicated, the defense would be, well, I didn't know I was intoxicated. I was not intentionally driving intoxicated. So in Kansas, you don't have to prove that. You just have to prove that you drove intoxicated. That's correct. But you still have to prove the act. The state doesn't have to prove that she intended to try to drive, but it has to show an act that shows an attempt to drive.
Stipulation did say that the car was in park. So I see it was an automatic, apparently, and the transmission was in park.
Okay.
Ms. Darrow was found asleep in her car by nearby homeowner. The car was on, but in park.
Okay.
So can we infer that, because we can make reasonable inferences from the facts, that if she's fumbling with the gear shift and it's already in park, then she must be trying to put it in some gear other than park.
Right, and there's not evidence to support that. There's no statement, she's not making any statement saying that. You would be drawing that possibility. You would be speculating that that's possible, that was behind her actions. And my only argument to that is it's also possible that she was doing it as a startle response. Given that Mr. Obermeyer has the burden of proof and there are two possible explanations for her actions, that's reasonable doubt. If she had the burden to prove she was innocent, then I might be in trouble here. But because he has the burden of proof and there's another explanation for her actions, that's not enough. It's possible that could be why she was fumbling with the gear shift, but there's other possibilities too. And you don't have enough here. You just don't. I think that concludes. Oh, the other point I wanted to make is Mr. Obermeyer mentions a couple times in his brief about the police officer arrested her for DUI. Like we should give some credence to what the police officer thought. But again, the police officer's arresting her because there's an inference she drove the car there. He comes upon a car, she's passed out, the engine's running. Like all these other cases, that's why he's arresting her. It wasn't later until the stipulation got entered. The officer didn't know that she had not driven the vehicle there. So I would save my remaining time for rebuttal. Thank you.
Well,
May it please the court, the state appears by Stephen Obermeyer. This case, I guess, presents an interesting issue as to the standard of review. And just for the audience, that's the level of deference that the appellate court gives to the trial judge. And we have two trial judges on this panel, and former trial judges on the panel. And in this case, we have a trial judge who made a finding of fact based on stipulated facts. I think the standard of review is what it usually is, and that is whether, looking at the evidence viewed in the light most favorable to the state, the appellate court is convinced that a rational fact finder could have found the defendant guilty beyond a reasonable doubt. The time for it's possible that she was doing this or maybe she was doing that was for the trial court's determination. On appeal, we are looking at whether a rational fact finder could have found her guilty beyond a reasonable doubt.
but we defer to the trial court and to the jury if it's a jury trial on those kinds of facts because we're sitting up here, we didn't see the witnesses. All we do is read the transcript and the briefs. We don't see how the witnesses react, whether they're breaking out into a cold sweat when the question's asked, whether their voice is trembling, whether their eyes are shifting around. You know, the fact finder has to weigh those kind of credibility issues, and so we defer to them because they saw the witnesses and we don't. But here, nobody saw the witnesses. It's just nothing but a piece of paper that says if they'd testify, this is what they'd say, and the trial court looked at that, and we're looking at the same piece of paper the trial court looked at. So why should we give any deference to the trial court?
Because the standard of review says that we give them deference as they're the fact finder.
In a case with stipulated facts, does it say that?
There are cases both ways on that,
Really?
I think,
Okay.
in the brief. I think we cited some that said it's a question of law, like interpreting a contract, but I think there are other cases that say it's this, whether a rational fact finder could have found the defendant guilty beyond a reasonable doubt. And I guess I'd say the same about what if we have a video of part of the transaction? Well, the trial judge looked at it. The appellate court, they can just do what they want if they disagree because they're the appellate court. I think you still give the trial court some deference.
Yeah, but a video isn't the whole trial. There are other
Correct.
witnesses that are, you know.
Correct. But so I think turning that language around on the standard of review, the appellate court can reverse if no rational fact finder could have found the defendant guilty beyond a reasonable doubt. And our contention is that a rational fact finder could have found the defendant guilty beyond a reasonable doubt. And just some of the facts here from the stipulation that was presented to the trial court. At 7:47 a.m., an officer is dispatched to an accident at a dead-end street at West 110th and Gillette in Overland Park, locates a silver convertible with the front of the vehicle into a chain-link fence. The vehicle is running because there's exhaust smoke coming from the muffler. The reporting party had approached the vehicle, sees the sole occupant passed out behind the wheel. The officer makes contact with the defendant, who is still asleep behind the wheel. The officer tries to arouse the defendant, who started to reach down and fumbled with the gear shift, but the car stayed in park. I'm skipping here. The officer determined that the defendant was operating a motor vehicle. The state conceded that the defendant did not drive to that location. Let's assume, well, we stipulated that, so I'm stuck with that. If I just want to sleep in a car that's running, do I want to sleep behind the driver's wheel? If I can find a roomier place to sit, if I just want to be drunk sleeping in a running car, number one. I think you need to look at her actions in there.
There was a movie about that, I think it was called Pre-Crimes. We don't arrest people for pre-crimes. That maybe down the road, when they sober up, they're going to try to drive, or well, later, they still may be drunk, that they're going to try to drive. Here, you've got to show that they operate or attempt to operate.
Correct. So if I'm drunk and I see the car that I'm in up against a chain link fence, if I want to sleep it off, I'll just stay in the passenger seat. Why would I get out of the passenger seat, walk around and get in the driver's side so I can sleep some more? I think you can look at those facts, because it's not roomier in the driver's seat if you've ever tried to sleep in a car. And again, the car is jutted up against the fence. Wouldn't you want to move it away from the fence and maybe get back over to the street or wherever the road is, because it doesn't sound like the car is on the road.
Defense counsel suggests, and I can remember as a district judge having a case like this where found a defendant behind the wheel. In the case that I had as a district judge, he was found parked in the bank parking lot. And there seems to be an inference, well, we don't know, he was too far away. He lived like 5 miles away, so he obviously didn't walk to his car. There's sort of an inference of he drove there. He was found sitting in his car with the engine running behind the driver's wheel. Here you have a stipulation that she didn't drive the car. Is that legally significant, as defense counsel suggests, in terms of sort of flipping this case maybe one way or the other?
I don't know if in your case the theory was that the defendant drove while under the influence or attempted.
The theory I used in that case was it was an attempt to operate.
Okay, attempt to operate. I think it seems like the cases back when we had alternative means, whether DUI was an alternative means, they'd look at whether there was an attempt to operate, which you found, or whether they had actually operated by driving to the bank and getting in the parking lot. And you probably had a sole occupant in the car. In this case, notwithstanding our stipulation that she didn't drive to that location, I think there's still an attempt to operate by her moving from whatever seat she was in into the driver's seat. And then when there's this car against the chain link fence, she's passed out, she wakes up and she reaches for the gear shift. So the car apparently was in park, and then she's fumbling with the gear shift, probably because you don't want to be jutted up against the fence.
And probably the issue is whether beyond a reasonable doubt.
I think a rational fact finder could find that she put her hand on the gear shift, fumble with the gear shift to move the car away from the fence. I think the stipulated facts would support a rational fact finder.
Maybe she was so drunk she didn't know she was in park and she was trying to make sure it was in park.
That would still be operating.
Putting the car in park so that making sure that the car could not, well, that would be like turning the ignition off. You're saying that when you turn the ignition off, that's operating the car? I would think, that's
No.
attempting to drive, that's attempting not to drive.
That's attempting not to drive. But I think if it was in drive and you're shifting it to park,
But we know it's in park. That's the stipulation, it's in park.
right. It's in park, so if she knows it's in park, then why are you putting your hand on the
It doesn't say she knows
shifter?
it's in park. We're limited to these stipulated facts. We can't go beyond what these facts are. It doesn't say she knows, it doesn't say she knows it's in park.
No, it does not say that, so we just have to proceed based upon inferences that she was fumbling with the gear shift in an attempt to operate the vehicle away from the fence. And I think the biggest fact would be her getting from the passenger seat to the driver's seat, because why else would you do that to get in the car? And then she's putting her hand on the gear shift. So I think in looking at all those facts, that a rational fact finder could have found that she was driving attempting to operate while under the influence of alcohol, which is stipulated the fact that she was under the influence to a degree that she was incapable of safely driving. So for those reasons, I would ask you to affirm the findings of the district court. Thank you.
Just briefly, it's really clear that this court has de novo review. Okay, so I think the rational fact finder standard, another way to say that is, are the facts in the stipulation sufficient to convict her beyond a reasonable doubt? I don't think we need to be talking about rational fact finder because we just don't have one in this case, but I don't think there's any difference. It's the bottom line here of, are the facts sufficient? And I agree with you about the pre-crime. I think the concern here, maybe by the state, even after the stipulation, is maybe she was going to drive away intoxicated, but we don't know that. She could have called a friend, she could have slept it off. We just don't know. And Mr. Obermeyer, again, is speculating about why she moved to the driver's seat. I put in my brief that maybe she turned the car on because it's December and she wanted to run the heater. And maybe she moved over to the driver's seat to smoke a cigarette because the window seat in the car was broken. The passenger seat was broken. And none of that's in the record, but it's a possible explanation for her actions. Because she wanted to roll the window down and the window on the passenger side was broken. Given that there are multiple inferences that can be drawn, the state has not proven their case beyond a reasonable doubt. And she's not guilty. That concludes my comments.
If these were facts presented to the jury through testimony, and you said, and you argued, well, they didn't prove that the passenger window wasn't broken, or that they didn't prove that she was a non-smoker and that the passenger window wasn't broken. Do you think you could argue on appeal that the state failed to meet its burden of proof in that,
Right.
in that instance?
So what you're sort of assuming is she doesn't testify.
Well, what I'm wondering is, to meet your burden of proof beyond a reasonable doubt, do you have to eliminate every conceivable possible explanation?
No, but when there is another possible explanation.
Well, you've dreamed that one up.
Right, right. So what I'm trying to say is the state just doesn't have enough here. They don't have enough. This is all that the state had, and they didn't want to give it up. And so they took this to trial and stipulated facts thinking, is this enough? It's just not enough. I mean, there's just not enough information here to prove their case. I'm not sure if that's answering your question, but okay. Thank you. Unless there are questions? Okay.
Thank you very much. That concludes our morning docket. I'll tell you what happens. Typically, the judges hearing the case go back and confer about the cases they've heard this morning, discuss them, and make some tentative decision. final opinions will be written up and generally completed within the next 60 days and circulated to the parties or possibly published, depending on how important the case is viewed. So we'll be adjourned until 1:30. We have a panel of, we have a schedule of 3 more interesting cases this afternoon. You're welcome to come back, or if you have friends, other classmates that you run into, you might remind them that we're going to be here and they're welcome to participate. Thank you.